Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, everyone, and welcome to another episode of Triage Podcast. My name is Sarah Carlins, and I'm here with my colleague, Carla DewBerry. We are partners in the healthcare group at K&L Gates. I'm in the Pittsburgh office, and Carla is in the Seattle office. And today we'd like to talk a little bit about a case that involves provider behavioral health claims. The case, in case anybody wants to look it up, is David Wit, W-I-T, versus United Behavioral Health. It's out of the Northern District of California. And what has happened is that United Health Group is appealing a 2019 decision in which the court held that the insurance company's internal guidelines for providing coverage for mental health and substance abuse treatment fell short of generally accepted industry standards. The court noted that the guidelines focused primarily on crisis management rather than long-term treatment that would be in the beneficiary's best interest. And I want to just quote what the federal magistrate judge, Joseph Sparrow, S-P-E-R-O, wrote, because I think it's instructive in understanding why they came to the decision that they did. And he said, quote, "The court finds by a preponderance of the evidence that in every version of the guidelines in the class period and at every level of care that is at issue in this case, there is an excessive emphasis on addressing acute symptoms and stabilizing crises while ignoring the effective treatment of members' underlying conditions. And this resulted in a significantly narrower scope of coverage than is consistent with generally accepted standards of care." And I think it's important that he really came to such a distinct conclusion. And in addition to that criticism, the court also noted that United Health Group had failed to take into account and consider properly the treatment of adolescents and children as distinct from the guidelines that were set forth for adult treatment coverage, despite the fact, obviously, that younger patients have different and distinct needs. So the ultimate finding there was that United Health had violated ERISA by improperly denying coverage for a class of more than 50,000 plaintiffs. And then what happened next, and this came in early November of this year, was that Judge Sparrow issued a remedies order in which he directed United to reprocess all of the claims at issue, as well as modify its handling of mental health and substance abuse claims in general. Now, United Health is also appealing that ruling and is asking the judge to stay that order pending such appeal. The company has said that reprocessing that number of claims would cost it over $30 million, which they say would be very difficult for them. Probably not surprisingly, attorneys for the plaintiffs don't believe that that's an astronomical amount for the company and feel that, in fact, quite a small penalty to pay for repairing the damage it did by improperly denying the claims in the first place. But the bigger issue here is an interesting one, and the case is being watched closely by insurers who are now realizing, that they may be held responsible going forward for having improper internal case handling guidelines. And Carla, I'll turn this to you in a minute here. I know that we've seen multiple suits in the last several years challenging payers for maintaining policies surrounding mental health treatment coverage that were inconsistent with generally accepted standards of care. And it's important to note that this case focuses on what UBH did under ERISA plans. So can you give us some general thoughts on this and why this matters for insurers under ERISA going forward?
Thanks, Sarah. I think we should be watching this case pretty closely because it raises a lot of issues. This is a kind of case that fascinates lawyers, but I think is going to have an impact on how plans respond to coverage determinations, at least in the ERISA framework. So let me talk a little bit about what went on in the case, and you can see then why the lawyers seem pretty agitated when you read some of their filings. So the judge made some determinations during the case, which set the stage for how the lawsuit went forward. So, for example, this was a lawsuit that involved many plaintiffs. And so one of the things you normally do when a multi-party litigation is that you go through a process to determine whether the case should be treated as a case involving multiple plaintiffs because their causes of action, their claims, are significantly the same. So the judge eliminated some plaintiffs from the lawsuit, but we went forward with, I think, more than 66,000 plaintiffs. That's a lot of people. So what are the plaintiffs looking for? And they claimed that the insurance company, which was the plan administrator, owed them a fiduciary duty in making determinations about what was covered under the plan. And that because the insurance company did not act as their fiduciary in making those determinations, that they should have claims against the insurance company. Now, keep in mind, because these were ERISA plans, the insurance company said that they didn't have a conflict of interest because they didn't save any money by denying claims. Since they weren't paying for those claims, they were really just administering the funds that had been put aside by the employers. So there are questions about what is the fiduciary duty of a plan that acts as an administrator with respect to an ERISA covered plan. And then the second thing that the judge did that is interesting is the judge decided that the plaintiff's lawyers did not need to prove what we call causal relationship of harm to the individual plaintiffs. So there was no breadth of testimony showing how each individual plaintiff or plaintiffs in groups were harmed by what the insurance company did. That's not part of the record. But even without showing that direct link of harm, the judge then entered this order which says reprocess your determinations about whether or not those plaintiffs should have been authorized mostly for a higher level of care. So the levels of care could have been inpatient hospitalization, residential treatment facility services, outpatient services at a hospital, and intensive services in other settings. So there were lots of different places that these patients could have been authorized for care. And some of the claims were that they were authorized for a lower level of care when a higher level of care would have been more appropriate if you just weren't focusing on the immediate crisis. If what you were focusing on was a path to wellness, you might have chosen a different place and a different program to provide the care. So the judge says, go back and reprocess 67,000 determinations about whether or not that person should have received a different level of care in the past. And in order to do that, the insurance company has indicated that they'd have to hire 106 physicians to evaluate the patient's standing back at the time they asked for the care, 78 nurses and other professionals, and 155 administrative staff. So the $30 million worth of costs that the plan is talking about is not the cost of providing the care. It's the cost of figuring out whether or not that patient should have been authorized for a higher level of care. And so if you do that work, then what comes next? So let's say they go back and they do that work and they determine that they made significant numbers of errors applying the standard that the judge says is the proper standard for determining the appropriate level of care. Well, these patients today are probably not in the same place they were back when they asked for that care. So what's the harm that we need to correct? If the patient paid for that care themselves, then the harm would be that you would probably have to reimburse them for what they paid out of pocket. But if they took the lower level of care, then maybe the continuing need is some additional services going forward. But you have to ask, what can we do for those patients? What's the corrective action for those patients? And because there's a significant dispute between the patients and the plan administrator over what do we do now, the plan says they want to go to a court of appeal. And so they went to the court, they said, stay your order. Don't enforce it now. Let the Court of Appeal make its determination about whether or not you got the law right, whether you were appropriate to not require there to be evidence about the individual harm to patients, and let's figure out what the corrective outcome should be. We want to have all that before a Court of Appeal. So stay your order. Just put it on hold until we go up to the Court of Appeal. And the judge, Judge Sparrow, said no, he was not going to stay the order. It is often the case that orders are stayed, and there's a lot of law about how you argue for a stay. And in this case, the judge said no, he wouldn't stay. And so they have to do this work now, even though they're going up on appeal on the substantive issues. So they may invest $30 million on doing work looking about what happened in the past, with respect to which we're not clear what the patients will actually get out of it. So I say it's a lawyer's case because there are all of these issues about the efficient operation of courts, the efficient road to justice. We all recognize that the court system is often very inefficient, but there is a lot of law now here on the table that will affect what should patients expect they're going to get out of these lawsuits. What's the risk for plans when they find themselves in this situation? What's the risk for an administrator? Are they a fiduciary? Do they have a fiduciary duty to these ERISA-covered individuals? And also the court did talk about the text of the ERISA plans themselves in terms of what is the standard of care that the ERISA plan said should be used in making determinations for their patients. So there's a lot of law that is in these cases. And it has the potential for changing the way we think about not only the care delivery system, but the consequences of not getting it right.
Very well explained. Stay tuned, and we'll be back on reporting on this when there's more to talk about. Thanks for joining us today. Be well. Talk soon.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.